100% sycophantic a president's lawyer.
But my Lord, when it comes, raising a new issue, that
which
is
the
never
issue.
Part of the recusal application.
That is not a new issue, my Lord. Let me proceed. My Lord, the Attorney General is the guardian of public interest. What is the public interest in a process of impeachment as we stand here today? My Lord, that public interest must be the country has been treated with an imperfect, I'll not go to the details, with an imperfect impeachment process at the National Assembly and at the Senate. When it reached towards the tail end of this process, the public will be treated to the fact that in processes that presupposed that you would take about 75 to 100 days were conducted within hours. So that the bigger questions, my Lord, would be that there is a complaint that is being made, a serious one, of the right to fair hearing and human dignity. Rights that are not derogatable under the Kenyan Constitution, even during an emergency. My Lord, if you are faced by an Attorney General who, pursuant to one mandate, their conscience has not been touched, that there is some public interest in looking at these things a little bit from the perspective of the Deputy President and those who feel like the Deputy President, that a fair and square deal has not been granted by the processes that have taken place. Your Lordships, that should concern us. I go to the next issue, the main issue that he cannot deny. He did say, my Lord, you are being told that we are in serious danger. We are in the throes of chaos or something like that. And there is some danger. My Lord, the truth of the matter is, the time that has been prescribed, thank God, by the Constitution itself, they are far from over. And the petitioners here keep saying, and Honorable Muite has told me, tell the court that if the court can be able to hear us from next Thursday when all of us have done responses and whatever amendment, we are ready to conclude that issue. We are ready, we know the timelines. So that, my lady, the connection, therefore, of somebody saying that, oh, the only public interest here, and this is the Attorney General, is that we must swear by hook or crook before the petition has been heard, that also should be a matter of grave concern.
Sure, because there was never a submission like that, and I think Council must have some respect for the truth. Nobody said anybody must be sworn by hook or crook. Please let's respect the truth.
My Lord, I think the language always in submissions belongs to Council, but what Professor Kibe Mungai, my former teacher, said is this, that we are in the throes of instability, something to that effect, because if we do not complete the process that was started by the National Assembly, a huge power vacuum might arise. And that it is why, when I use hook or crook, it is why the only obsession that we hear, or conservatory order taking out, that is the context. My Lord, I go to the next issue. Who is this who made the oath of office of Professor Ojenda? My Lord, there was the question of CTS. The question of CTS, I believe, had dealt with it, and all those kind of issues, and we pointed out that the issues of CTS, whereas we had talked about them, they appeared for the first time not from the respondent's affidavit, but from the ruling that the court made. I don't need to say anything about it. The respondents had said nothing about them. My Lord, to Professor Ojenda, there is a question of... no, I have to respond. There is a question of the internal memo. The question of the internal memo, again, that was not a matter that was ever placed here in any affidavit, as far as I'm concerned.
That was yesterday's submissions.
I think you were here.
I think these are not for today.
Those are not for yesterday.
No, these are notes for today, my lord.
That was yesterday.
No, my lord. If they have a date and I had a different notebook, but they would get uncomfortable. Let me pass that. In fact, he's not the main guy I have to deal with. These issues, he talked about the internal memo. But well, if he says he didn't, let me hope I imagined it. I can pass it. But that's what my note says. I don't mind. We can't fight over a memo. And as I said, we are dealing with some other submissions. My lords, my lord, there is a question of Mr. Nyamodi. And Mr. Nyamodi was talking about the issue of the
Time is up. Just sit down.
Just to confirm, we have not touched his notes.
Allow me to remind him what I said.
No, the only misplacement was this guy.
My lord, maybe we should correct that as well, because it's been said 3 times. There are no guys in court. They are learned counsel.
My learned colleague, professor, is the only issue, the reference, senior counsel. Is that doubted? My lord, the issue that would require the clarification, let's go to Kerogoya. I believe there is no doubt about the issue of Kerogoya. My lord, the issue that was raised, and I believe this is the last point that Professor Muigai was making, regarded the issue of where it was alleged that the issue estoppel with regard to the issues of Kerogoya that found themselves in the ruling of yesterday. And my lord, first of all, I wish to point out that there is a notice of appeal that is one of the annexures in the supplementary affidavit and raises specific issues about preempting and the issues dealing with matters that were yet to be handled. I need to clarify that is one of the issues when it talks about the issues of res judicata. And when it comes also to the issues of res judicata, it is important, my lord, that it is pointed out what was the subject matter of yesterday's application. It was the interpretation and application of Article 165(4) of the Constitution in relations to the powers of the Deputy Chief Justice. The said ruling, anything else that may have been said that was outside that is direct issue that was before the court, that was not an issue for that ruling. And therefore, dealing with matters that are outside there and you are be told the ruling has dealt with those matters which it ought not to have dealt with, so it has become res judicata. It cannot become res judicata in our submission. They have been preoccupied with, my lord, nobody is trying to criminalize friendships, not at all. But my lord, there are always degrees of friendships. When it is alleged, for example, that a friendships between Kibe and Ndegwa is of such a close proximity that Kibe and Ndegwa ought to disclose that fact to any other person, it would be different, for example, to my friendships with Harvey, somebody we just meet and do a few cases with. So that, my lord, the issue at the end of the day is one of degree. To what extent are there interactions between these two individuals. Because, my lord, and we were saying that you may feel that there are issues. Issues could well be raised. That who was so that, for example, was Judge Mrima from the Kenya Law Reports records, as people would be sending materials to indicate that, the lawyer for Mheshimiwa Kingi during the case with Esposito? Again, the answer would be yes. So this is not a casual friendship. It is a friendship that is over. There have been had client-lawyer relationship, other personal relationships are all there. So that, my lord, you cannot be able.
Now, how do we respond to that?
Mr. Kibe.
Yes, my lord.
I had intended to restrain myself.
Yes, my lord.
From interjecting in these applications. But I think the statement you're making is factually incorrect. In the Esposito matter, I appeared as the advocate for IEBC, not Mr. King.
Thanks for the clarification. My lord, the issue...
I think if we people can respond on issues of law, it would really help us, rather than going back on issues of facts.
Yes, so that, my lord, there was a question of forum shopping. Forum shopping, I go with what Ms. Ndegwa has said. If this bench recuses itself, it does not mean that we shall choose any of the judges that may replace this bench. For as much as the issues of Mr. Mushemi is concerned, I urge this court to disregard them. There are two other more important issues that we need to point out. My lord, using the test of the reasonable man and woman in Kenya, it is a question of splitting hair. President Ruto and Tuya. Is splitting of hair for the simple reason that during even the Senate proceedings themselves, we were treated to a situation in which, and one of the principals was indicted, in which political positions at cabinet, board levels, and others were toss-ups for purposes of political dealings. The average knowledge, because that is the standard that you've said, a reasonably informed Kenyans is aware that any new government comes to office with its own appointees to those board positions, permanent secretaries, and others.
Mr. Kibe, you are going beyond what is really necessary for this. I think you have made your submissions. Respect the court and your colleagues. Reply on issues of law, please.
I thought that was an issue of law.